welcome to When Bankruptcy is Filed During Divorce. What happens next? I'm Ryan Wedeking, an incoming co-chair of the Beverly Hills Bar Association's Family Law section. Our section is sponsored by White, Zuckerman, Orzovsky, Luna, and Hunt LLP. White Zuckerman provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. We have so many great programs coming up over the next month or so, so please mark your calendars and register now if you haven't already for the following. On October 14th, we have a fireside chat with Judge Kaufman and new family law judges. On October 23rd, also with Judge Kaufman, we have parenting plan assessments, the LA County practice overview. On November 1st, we have our annual family law symposium. This year the symposium is called Order in the Court, Tactics for Addressing Bad Faith and Incivility. That is going to be a fantastic program dealing with a number of troublesome issues at the family law bar and bench. On November 5th, we have the State of Department 2, one of our annual in-person flagship events. And on November 15th, we have spotting and managing SLAP issues in family law. And that is SLAP, S-L-A-P-P, of course, not a domestic violence topic. Other exciting programs are on the calendar and in the works, and you are also welcome at our family law section meetings on the third Wednesday of the month at 4:30 p.m. We plan events, hear directly from Judge Kaufman and other bench officers, brainstorm new ideas on cases, and sometimes even have fun. Now, let's get to the program. I'm delighted to introduce today's speaker, James P. Menton Jr. James is a partner and chair of the Corporate Restructuring and Bankruptcy Group at Robbins Kaplan LLP. He represents clients in fiduciary disputes, creditors' rights and remedies actions, corporate bankruptcies, and complex commercial litigation. He has decades of experience resolving high-stakes matters involving multi-million-dollar claims. Drawing on his extensive network and litigation experience, he provides strategic counsel to debtors, creditors, fiduciaries, trustees, and other parties in distressed corporate situations, asset recovery, and restructuring. And crucially, for today's audience, he also assists family law attorneys in addressing bankruptcy claims where a party has filed a bankruptcy petition while a dissolution action is pending. So thank you, James, for joining us today. And with that, I will let you take it away.
Thank you, Ryan. Appreciate the opportunity to speak today to all of you. Why don't we get started? First slide, please. So I just thought I'd start with a quote. In my world, bankruptcy sometimes happens quickly, and sometimes it's long attenuated. This is a quote from The Sun Also Rises by Ernest Hemingway. There are two characters that were chatting in the book, and one of them asked, how did you go bankrupt? And the response was two ways: gradually and then suddenly. And that's been my experience in my practice. I'm not sure if you've run into that in your practice, but I thought it might be apropos for today, where I think sometimes bankruptcy happens quicker than we had anticipated. Next slide, please. So with the filing of the bankruptcy petition, there's what's called the automatic stay, and it's automatic. It's an injunction issued by the bankruptcy court, but as I said, it's automatic. And what that does is it's fairly broad-based, and it does a number of things to kind of put a stay or a hold on things that happened prior to the bankruptcy. Among other things that it does is you're prevented from starting or continuing lawsuits or collection efforts against the debtor. You're also prohibited from enforcing judgments or trying to create or perfect liens against the debtor or property of the estate. You're also prohibited from taking or controlling property of the bankruptcy estate. you're also prohibited from collecting on pre-petition um, bankruptcy debts, as well as offsetting those debts against the debtor from before the case. Again, the concept is it's automatic, and it's trying to put a hold on things so you don't have a rush to the courthouse or otherwise in order to take a hold of assets of the debtor or property of the state before those kinds of matters are addressed in the bankruptcy. Next. Fortunately for many of us, including in the family law space, there are certain exceptions to the automatic stay for domestic matters. Importantly, those include paternity actions that are ongoing. It also deals with domestic support orders. Either the commencement or modification of those domestic support orders are not stayed by the automatic stay. Also, child custody and visitation matters are not stayed by the automatic stay. And then the divorce itself is not, but with one exception, the idea that if you're dividing what's considered property of the bankruptcy estate, then that is stayed. In other words, the bankruptcy court has an interest, as do the creditors in the bankruptcy, for making sure that property of the estate is divided as appropriate as the bankruptcy court determines. And so the idea you can go forward with divorce, and we'll get into this in a bit, but you'll need to get relief from stay in order to do dealing with issues of dividing of the estate property. And also what is accepted from the bankruptcy stay is domestic violence proceedings. So those can move forward. There are other exceptions to help enforce the domestic support obligations, and those include collecting support obligations that are not part of the bankruptcy estate. So if the debtor has separate property, you can pursue that. There's also the possibility of moving or seeking wages to kind of garnish or attach wages to satisfy a domestic support obligation under a court order or perhaps government agency orders. You also have the ability, in order to bring pressure to bear, if you will, on having licenses suspended, professional licenses, recreational licenses, things of that nature. You also have the ability to report the overdue support to credit agencies. So you're able to do that, as well as essentially intercepting tax refunds. With the concept of, obviously, domestic support obligations are very important, and they need to be paid. And so the bankruptcy code provides these opportunities to kind of enhance rights in terms of trying to get those paid, irrespective of the bankruptcy having been filed. Next slide, please. So here's the Grunts case, which is a case in the Ninth Circuit. What was interesting about that case, because it did deal with the automatic stay, and this was a case where a woman was domestic or support obligations were owed. They were not being paid, and so the ex-spouse, pursued or went to the authorities and started criminal proceedings were started, and there was a conviction. And that happened twice. And what the debtor did is the debtor tried to suggest that it was in violation of the automatic stay, because what the ex-spouse was trying to do was to collect on a debt. The court didn't buy that, if you will. The court basically said that under the bankruptcy code, criminal proceedings are also accepted from the automatic stay, and it said that whatever the motive is for those proceedings to go forward, even if the ex-spouse did have that motive, that was not relevant based on a plain language meaning of the statute. And then it was really the authorities, in this case the state authorities, that were going forward with that. So the court found that it was not a violation of the automatic stay. What's also important here is that this was a state court that found that the automatic stay did not apply. And so the concept here is that family courts can't modify or lift the automatic stay, but they can decide whether it applies or not. And in this case, they decided that it did not apply. So if the family law court were to do that on a matter before it, that certainly would be subject to review by the bankruptcy court. I just caution you, however, that if you go forward and in the family law court and it's ultimately decided that it was in violation of the automatic stay, or a lifting of the automatic stay or modification, if they're taken up by the bankruptcy court upon review, that could be considered void. If it is that, then that would be considered void. And so that creates some complications there. So as a practical tip or point, you may want to consider, if you have these issues out there, as to whether the automatic stay applies or it doesn't apply, or whether it's accepted. One thing you can do is go in front of the bankruptcy court and seek clarification whether the stay applies or not, or in the alternative, to provide relief from stay in order to proceed with the matters that you're interested in. So when I mentioned before that the idea that the divorce proceeding can go forward, but what is stayed is the notion of the division of property of the bankruptcy estate. And so what you need to do in that regard is you need to seek relief from stay under 362D of the bankruptcy code. And you can seek relief from stay for cause, which is not defined in the bankruptcy code, and so it's decided on a case-by-case basis. Bankruptcy courts, when considering relief from stay matters, tend to focus on matters such as judicial economy, the state court expertise, and the estate's interests in whether to grant relief from stay or to modify the stay to allow the family law proceeding to go forward with respect to division of property of the estate. In my experience, bankruptcy courts are interested in and generally defer to bankruptcy courts on such matters given their expertise. That's McDonald is a case that is cited in some other materials that you'll be getting after the program that makes that clear. And then in Sandoval, that was an interesting case here in the Central District of California, a bankruptcy case. The bankruptcy court said basically, from its perspective, there were two methods to deal with this notion of division or determination of the property of the estate and how it's to be divided. One was for the bankruptcy court to do that, and the second option was to have that go forward in the family law case, but with certain protections in place. And in this case, the bankruptcy court was concerned about collusion. This was a case where there was property, the house that was owned by the debtor's parents, and they had title was taken by the debtor and her ex-husband, and it was unclear as to who owned the property, who owned equitable and legal title to the property. Anyway, so went into bankruptcy. The spouse who had not filed bankruptcy filed a proof of claim in the bankruptcy saying that he was entitled to $70,000 of that house. And basically what they did is they ended up settling that matter. What the bankruptcy court allowed them to do was to go to the bankruptcy court to deal with issues concerning the characterization and division of that property, but that the bankruptcy court would treat that as a proposed settlement. Then you'd have to go back to the bankruptcy court and get approval of that. So to go back, what happened in this case is as I said, the ex-husband had filed a proof of claim saying that he was entitled to at least $70,000 of the equity in that house, and they entered into a settlement agreement in the family law arena where basically he got money. The house went to the parents, was transferred to the parents, and the bankruptcy estate got zero. And the bankruptcy court wasn't. And then a motion was brought in the bankruptcy court to approve that, and the court did not approve that. The bankruptcy court decided there was collusion going on, that it didn't make any sense that the husband or ex-husband was getting $70,000 and the estate was getting nothing. At a minimum, the bankruptcy court opined that the estate should be getting something, and certainly perhaps not less than $70,000 if the husband was entitled to $70,000. So that is kind of a situation where how one bankruptcy court kind of dealt with the issue about how to deal with the division of property, the estate, its characterization, and its division. Next slide, please. In another case, the Menton case out of South Carolina, the court did it a little bit differently. Didn't seem to be so concerned about the collusive aspect of things, but certainly wanted to protect the bankruptcy estate and its creditors. And so what it did in this case, it allowed the state court, the family law court, to go forward with its determination of the apportionment of the marital assets. But then it prohibited basically any further action to collect, recover, transfer, encumber, or liquidate that estate property without further bankruptcy court order, and it retained the ability to review the family law court's determination as it related to estate property. So what's going on here is this balancing act of understanding the expertise of family law courts to deal with these kinds of issues, among other issues in the family law arena, but then being very mindful of the bankruptcy itself and creditors and what makes sense from a bankruptcy perspective. And so courts grapple with how to deal with that. And these are examples of two courts and how they've addressed it. So when you're thinking about this stuff, think about what makes sense from your perspective in terms of that division, and rest assured you're going to probably have some bankruptcy oversight in one form or fashion. So that's not surprising and is to be expected. In terms of relief from stay practice, there are forms that one needs to fill out. You want to support that with a declaration for relief from stay for cause. And in connection with that, typically these orders have a 14-day stay, if you will, of the effectiveness of that order. So what I've done in the past is request a waiver of that so that it becomes effective immediately. And then also, as I've mentioned previously, you may want to consider seeking relief from the bankruptcy court to get clarification on whether the automatic stay applies, or a comfort order to say that it, again, doesn't apply, or to get relief from stay in the event that it does apply. That's a potentially prudent course of action to take if there's some confusion, or you don't want to run afoul of the bankruptcy estate, because running afoul of the bankruptcy estate, as I said before, can impact what happens in the family law court in terms of it being a void judgment or whatever, but also there are potential sanctions and whatnot that could be requested anyway if there's kind of a willful violation of the automatic stay. So you will obviously want to try to avoid that. Next slide, please. So we talked about or alluded to bankruptcy, the property of the bankruptcy estate, and kind of what is that. It's fairly broad-based. Under 541A of the Bankruptcy Code, it includes all of the debtor's legal and equitable property interests as of the petition date. It includes community property, basically under the debtor's sole or joint control, and also community property that's liable for the debts of the spouse and the non-filing spouse. It includes property recovered from avoided transfers, also property acquired within 180 days of the bankruptcy by inheritance, divorce, or death. Also includes rents, profits, proceeds from estate property, and then property of the estate acquired after the petition date. So it's fairly broad-based in terms of the expansiveness of what is property of the estate. As a further amplification, or just as a supplement to that, in individual Chapter 11, Chapter 13 cases, the estate includes post-petition property and income earned before the case is closed, dismissed, or converted. And then there are certain exceptions to the what's property of the estate, or exceptions, or not considered not property of the estate, and that excludes if you have a power that you're working for the benefit of from someone else, vis-a-vis valid spendthrift trusts. that's not property of the state or is excluded from it. And then in terms of property of the estate and how that's determined, what law applies, it's state law determines those issues rather than federal law. And the notion is that, let's say the bankruptcy, you've got the family law case going forward, then bankruptcy is filed. If there hasn't been a court determination, a family law court determination as to the division of that community property, then it's all considered, upon the filing, it's all considered community property. So that'd be something to be mindful of. And that was basically what the Menton case was talking about. So the Bankruptcy Code provides for certain exceptions or exemptions, if you will. And there's the bankruptcy exemptions, and then California has its own exemptions. In California, we've opted out of the Bankruptcy Code exemptions, and so what you focus on here in California is California residents. You focus on the state law exceptions under CCP section 703 and 704. And debtors can avoid judicial liens that impair, and we'll talk about judicial liens a bit later in the program. Debtors can avoid judicial liens that impair the exemptions. The one exception to that is for domestic support obligations. And then there may be other laws out there, California or in other states, that somehow prohibit going after exempt assets, but those are kind of excluded, if you will, under the Bankruptcy Code. So those wouldn't prohibit you from going after exempt assets for if you're a support creditor. So domestic support obligations, a key concept in the family law context, in the bankruptcy world. A domestic support obligation is a debt, including interest for in the nature of alimony, maintenance, or support owed to a spouse, former spouse, or a child of the debtor. And it can arise before, during, or after bankruptcy and must be based on a court order, a separation agreement, divorce decree, marital settlement agreement, or government determination. And it can't be assigned to a non-governmental entity except for collection purposes. So the question is, what is a domestic support obligation, and how is that determined? And really, the focus is not so much on the language per se, but it's focusing on the intent and what's the substance of the obligation. So in other words, not just the language or the payee. And what's important here is those. So for instance, in my experience, and the case law provides that domestic support obligations may include, debts of the ex-spouse, the non-filing spouse's attorney's fees, and we'll talk more about that later. Mortgage payments for the ex-spouse, the residence of the ex-spouse, or educational expenses. So the idea is it's for the welfare and benefit of the ex-spouse or children, for example. What's important here is that domestic support obligations are non-dischargeable under the Bankruptcy Code under 523A5. And what I mean by that is that typically when you file a bankruptcy, the individual will get a discharge in the bankruptcy if things go as they typically go. And what that means is that the debtor no longer has personal liability on those pre-petition debts. And so when we say non-dischargeable, what that means is that carries through. So in other words, for domestic support obligation, that means that those obligations prior to the bankruptcy, during the bankruptcy, and after the bankruptcy are not dischargeable, meaning that it's a personal liability that continues on even though there's been this bankruptcy. So that's very critically important here, and why you want to have domestic support obligations. Particularly for you, if you're an attorney representing the spouse who didn't file bankruptcy and you want your attorney's fees paid, it's important. One vehicle for getting paid is to have that characterized and considered as a domestic support obligation, because, as I said, that rides through through the bankruptcy, and it's also important in the sense that it's given kind of a super priority, if you will, in the bankruptcy. Within the bankruptcy, there is a kind of a waterfall of who gets paid and when, and this is the domestic support obligation is a higher priority, so get paid out before other unsecured creditors. So that's another important aspect of domestic support obligations, and why and how it's played out in the bankruptcy, and why it's important to be sure that you have a domestic support obligation, not only if you can for your attorney's fees, but also for your client whom you're representing in the family law context. As I've mentioned before, the debtor receives a bankruptcy discharge that eliminates the personal liability, as we mentioned. There are, in addition to 523A5 that I talked about, and I'll talk about 523A15 in the next slide or two, but there are other non-dischargeable obligations that I'd suggest one keep in mind, and those include for money, property, or services that were obtained by fraud or false pretenses, 523A2, fiduciary fraud or embezzlement, 523A4, and willful or malicious injury under 523A6. So in this particular context, in the family law context, suppose you're representing someone your clients in family law, and suppose the spouse has during the marriage has committed, what you perceive to be fiduciary fraud or embezzlement of community funds, or maybe even of separate property, or engaged in kind of willful or malicious injury to your client or to your client's property. One way to address that, aside from this 523A5 matter, which that's a domestic support obligation, but this is something different. That this is basically your client having been injured by these kinds of activities. And so what you can do is you can file in the bankruptcy court a complaint arguing that the debt for, let's say, fiduciary fraud or embezzlement, or for willful or malicious injury, should be accepted from the discharge as well. And that typically is a complaint that you file as an adversary proceeding, and then you actually go to trial in the bankruptcy court on those issues. And if you are successful, that debt would also be accepted from discharge. It'd be a non-dischargeable debt, meaning that the debtor would still have personal liability for those damages as well. It's important to keep in mind for these particular debts that are non-dischargeable under 523A2, A4, or A6, that there's a timeline, there's a time frame, if you will, for bringing those in the bankruptcy court. So in other words, you just can't bring it at any time. And that deadline is, in the bankruptcy world, after the bankruptcy is filed, there's typically what's called a 341A meeting of creditors that is scheduled. And what that means is that the U.S. Trustee's office will schedule a meeting with the debtor where creditors can show up. And during that time, the debtor's under oath, and they answer questions about their bankruptcy schedules and a whole variety of things, basically about the bankruptcy case and their assets, liabilities, documents, things of that nature. So once that's scheduled, you'd need to file the 523A2, A4, or A6 complaint within 60 days of that initial scheduling of the 341A meeting. In my experience, that 341A meeting of creditors tends to get continued for a variety of reasons, scheduling, or maybe it happens, and then it gets continued to another date in order for the debtor to provide more information or documents for the trustee to maybe do some more investigation. But the continuation of that 341A meeting doesn't change the timeline or the time frame by which you need to file the 523A2, A4, or A6 complaint. So consider once the bankruptcy is filed, whether you have these type of debts that potentially are non-dischargeable, and then strategize and think about whether you want to bring that complaint and be mindful of the deadline for doing so. So we've talked about non-dischargeable debts under 523A5. What's debts that are non-DSO debts, that are property division debts, basically like equalization of property and whatnot in the bankruptcy case, that can be non-dischargeable under 523A5 or 523A15. Those debts in Chapter 7 and 11 are completely non-dischargeable, but in a Chapter 13 case, 523A15, for those non-DSO debts, property division debts, those can be dischargeable. They could be provided for in a Chapter 11 plan, and so long as that plan is consummated, where in other words the debtor satisfies its obligations under the plan, then those would be kind of discharged, if you will. So it's mindful here. It's important to when you have a Chapter 13 case, to understand what debts are being characterized and how they're being characterized, and whether they are, suppose it's a domestic support obligation under 523A5, but it's being characterized as a 523A15 debt, then you'd want to be proactive on that, and reach out to the debtor to try to get clarification there, or to get things modified. And if that doesn't work, then the concept would be to seek relief in the bankruptcy court to make sure that things are not mischaracterized or mistreated, because the downside in a Chapter 13 case is that it could be considered, assuming it gets consummated, it would be dischargeable under the Chapter 13 plan. That's not the case in Chapter 7 or Chapter 11. So it's helpful to understand how debts are being characterized in the bankruptcy by the debtor, and whether that comports with your sense or understanding about what those debts are, and to be proactive in seeking relief to protect your client's interests in the bankruptcy. So I've seen some commentary among the case law about state and federal courts' shared jurisdiction over determining debts subject to or accepted from the debtor's discharge, except for 523A2, A4, A6, applying bankruptcy law. If in doubt, I would suggest go to the bankruptcy court to get clarification there, so there's no confusion in that regard. We've talked about debts that are non-dischargeable. There's also, under the bankruptcy code, and we talked about getting discharged from personal liability, there's also the opportunity to seek to have the debtor not get a discharge generally, for all obligations, and that's under 727, and that's for basically bad acts, if you will, under the statute, and it can be considered such things like the property disposition was fraudulent, or failure to preserve records, or withholding of information, or providing false testimony, not disclosing assets on the schedules, basically defrauding the bankruptcy court and creditors, and disobeying court orders. So there is a vehicle to seek to deny the discharge of the debtor generally. That is by filing a complaint. So that's another potential resource or leverage point that one can use in the bankruptcy, not only to have this non-dischargeable debt aspect of things, but also to basically request that the court deny the debtor a discharge. That's through filing of a complaint in the bankruptcy. So let's turn a little bit to litigation and avoiding powers under the bankruptcy code. So what I often run into is preferences. The notion of a preference that's typically the debtor has, the trustee in bankruptcy says within 90 days prior to the bankruptcy that the debtor provided money to the client or to others on for antecedent debt, or within a year for an outsider, and that the person who received the money got more than they would in a Chapter 7 liquidation. There are certain defenses to preferences in terms of contemporaries providing new value and an ordinary course of business transactions and transfers. The good news here in the family law space is that domestic support debts are exempt from avoidance as a preference. So that's good news. So the bad news is that potentially payments on non-DSO debts within that period may be challenged as preferences. Typically what happens in my experience is that the Chapter 7 trustee will send out a letter in advance saying, look, asserting that certain payments were considered preferences, and then there's an opportunity well in advance of the deadline for filing those preference actions, which is 2 years after the bankruptcy is filed. And so there's an opportunity to educate the trustee and to try to work something out to reach resolution on that. And I've done that. Sometimes that works, sometimes that doesn't. If it doesn't work out, then potentially, and a lawsuit is filed, then maybe pre that filing, you've been able to reduce the amount at issue for purposes of litigation, or if you can't reach a resolution, then the complaint is filed in the bankruptcy court, and you kind of litigate that like you would other matters. And then, so that's kind of preferences. There's also fraudulent transfers. Fraudulent transfers under the bankruptcy code under 548. There's actual fraudulent transfers under 548, and also constructive fraudulent transfers. Those are brought within 2 years of the bankruptcy. So sometimes you will get a letter in advance from the trustee saying, I believe you've also received a fraudulent transfer, or we believe you received a preference, but if it's not that, it's a fraudulent transfer, or vice versa. So in terms of actual fraud, it can be shown by direct or circumstantial evidence. A lot of times you don't have someone actually saying, yes, I affirmatively wanted to commit fraud here. And so you look at various factors, including when these transfers were happening, there's pending litigation, were you transferring most of the property, was the debtor insolvent at the time, was there a special relationship, was the debtor transferring all the assets to his spouse, to siblings, relatives, whatever. Was there a transfer that actually happened, or it looks like it happened, but it really didn't because the debtor kept, essentially retained the property. So those are kind of the facts and circumstances that you want to look at to see if, support the notion of an actual fraudulent transfer, or that's what they will look to. And then obviously if you're on the defensive side, you'll want to try to push back on those factors and argue that it wasn't a fraudulent transfer. Yeah, we talked about kind of within two years of the bankruptcy, and recently on the constructive fraudulent transfer side of things, did the debtor not receive mutually equivalent value for the transfer, or an obligation incurred while the debtor was insolvent, or another test is kind of being undercapitalized, or believed or reasonably should have believed that paying debts was going to be incurring debts beyond his or her ability to pay. And so that's kind of the constructive fraudulent transfer scenario. And then the Ninth Circuit, as I indicate here, equates reasonable value with fair market value, assessed from the creditor's perspective based on all of the circumstances. And then 548 deals with self-settled trust that have been common in various jurisdictions, and that the Bankruptcy Code provides the opportunity to go back 10 years to look at those self-settled trusts to see whether those were set up and operated essentially to defraud creditors.
James, it actually looks like we have one question if we do have the time for that.
Absolutely.
I have Mr. Jack Russo is asking, Can non-married Marvin v. Marvin partners get DSO relief, or is that only for married folks? What about civil partners?
I, I haven't dealt with that issue before, but I think an argument can be made in that regard. But as I said, I'd have to research that further. I haven't dealt with that, but I think arguments should be made in support of that.
Thank you.
And then one is kind of the avoiding of the transfer itself as a fraudulent transfer, and then there's also from whom you can recover. And you can certainly recover from the person who received the funds, and also for someone for whose benefit it was received. If you are a subsequent transferee, but that provided good value, in good faith and for value without the notion of the avoidability of the transfer, then that can be a safe harbor, if you will, to get to not have that liability, that exposure as a transferee. And then 544B really what it allows you to do is use state law, fraudulent transfer law, in order to avoid fraudulent transfer. So in this case, under California law, same kind of concept apply in terms of actual fraud and constructive fraud. So those are general. We're running a little short on time, so I want to kind of speed up a little bit. So why don't we go to the next slide, please? Next slide. And the Mejia case, that's just to say that marital settlement agreements, they are subject to fraudulent transfer statutes here in California, certainly. And so you want to be mindful of that. Next slide. So I want to get to attorney's liens for practitioners out there. The notion is the state law applies to the kind of the creation and the validity and perfection of liens in bankruptcy. And the point here is that upon the filing of the bankruptcy, the trustee is considered a hypothetical judicial lien creditor, as well as a bona fide purchaser with authority to avoid unperfected liens. So the notion is, if you don't have if your client, or from your perspective for your attorney lien, if it's not perfected prior to the bankruptcy, then you run into the prospect of the bankruptcy trustee seeking to blow that lien off, if you will, or to say that to avoid that lien, which then renders you kind of just a general unsecured creditor. An example of this case of that is In re Bush, 356 BR 28. In that case, it involved someone who was representing the debtor in family law proceedings, and then the debtor went bankrupt, and the family law lawyer was claiming not only a charging lien, but a fee stipulation, a lien, considered a fee stipulation as a judicial lien, and also had a family law real property lien, and that all was contested by the Chapter 7 trustee. And so the highlight there is that there was a fee stipulation that basically said that this attorney's fees would be taken out of the proceeds from the sale of property. But unfortunately for the attorney in that case, the fee stipulation was not recorded. So in other words, even though it was entered in the family law case, it was not recorded, and so therefore the court said that the Chapter 7 trustee, as a hypothetical judicial lien creditor and as a bona fide purchaser with authority to avoid unperfected liens, did not have constructive notice of that unrecorded fee stipulation, and therefore that was not considered a lien under the bankruptcy, well, for purposes of the bankruptcy case. So that was not a vehicle that the attorney could use to claim a lien on the proceeds of the property. Next slide, please. So in terms of family law attorney real property liens, you all know the statutory bases for that under 2033. And in this Bush, the same case that we were talking about, in that case, the attorney also asserted a real property lien as well. And in this case, in that aspect of the case, the court agreed, even though this notice of lien had not been done under 2033B. The attorney had recorded an all-inclusive deed of trust, and the court said that provided constructive notice. And so therefore the attorney did have a lien on the proceeds based on the perfection and the recording of that all-inclusive deed of trust. The Henry Scott case talks about the idea that the family law real property lien is not a judicial lien, and therefore it can't be kind of avoided under 522F1 that talks about avoiding of judicial liens or avoiding liens that impair exemptions. And so that's critical to know. And then in this case, the argument also was that when you have your real property lien, it's against your client's community property interest and not against the debtor. And so therefore, that was also, in the Scott case, a basis for why did not find an issue or problem with the real property lien, or why it couldn't be avoided. So also in the so we've got the judicial lien, we've got the real property lien. We also have charging liens. I don't know how many of you have that as part of your practice as well. A charging lien, as you know, is made pursuant to contract, and they remain enforceable in bankruptcy even if the judgment is entered after the petition date. So for instance, if you have a charging lien and you're entitled to the proceeds resulting from property that's obtained in the context of that dissolution, then even if that ends up getting consummated after the bankruptcy, you arguably are still, if you have that lien, you're still entitled to the proceeds of that. In that case, the Pacific Far East Lines case was exactly what happened there, where and it wasn't in the family law context, but it was in kind of the charging lien general context, and there was a contingent fee arrangement, and then the bankruptcy was filed, and then the retainer agreement was rejected in the bankruptcy, and we don't have really time to go through that today. But anyway, so notwithstanding that, the attorney was allowed the reasonable value of its services, and even though that deal was consummated after the bankruptcy, the court found that the lien did flow through, if you will, that the attorney did have the right to recover a contingency fee, consider the reasonable amount of its services in that case, notwithstanding the bankruptcy. So that's important to know. So in the charging lien context, in order to have a valid one, obviously you need to comply with California law. I cite the Fletcher case there. In other words, you've got to give the right for them to seek independent counsel, advise them of their ability to do that. I've seen cases where when that was not done, you didn't have a charging lien. And then this Tri-Valley case, this was a case where a charging lien was claimed, but the complaint itself did not plead that the compliance with Rule 3300. The attorney argued that it wasn't necessary to plead that in compliance with Rule 3-300. The court found otherwise. The court gave leave to amend for them to try to figure all of that out, to give them another opportunity to see if that was the case. So be mindful of that if you are pursuing charging liens in terms of compliance with Rule 3-300, and then be sure you're pleading it correctly. And then in the Henry Bush case again, the debtor's attorney in the pre-petition dissolution proceedings was entitled to summary judgment confirming that the attorney's charging lien attached to the proceeds of the debtor's real property. The issue there was whether the charging lien, whether the language in the underlying agreement provided for a charging lien against the real property and an equity interest in the real property and the proceeds, and the court found that was the case. The court found that the California law provided for the ability to have such a lien outside of that family law, those family law statutes that I that we just talked about. And the court ultimately decided that the court also looked at some of the circumstances, looking at the intent of the parties as to whether the real estate and the proceeds were subject to the charging lien. The court found that all of that came together, if you will, to support what the attorney was saying. So as support the court found that the attorney's charging lien attached to the proceeds of the debtor's real property, as I indicated. So as a practical tip in that regard, in terms of charging liens, one, you want to be sure that you're creating one validly under your attorney agreement. And we know that perfection typically the charging lien is perfected upon the execution of that agreement. If real property is in play in connection with the dissolution proceedings and your representation of the client, consider making sure that the real property is specifically identified in that. Otherwise, you get into issues, as they did in Bush, about what the characterization of the looking at the language itself and what the intent of the parties was. So it may circumvent that kind of discussion by explicitly covering that real property. And then this concern about, in Bush and obviously in other cases, about having constructive notice. And so even though your attorney lien, the charging lien is perfected upon, it's having been executing the retainer agreement, consider actually recording that in the county where the real property is, to provide that constructive notice. And so that would be something to do in anticipation, potentially, if there is a bankruptcy later, that the trustee will try to say, no, there wasn't constructive notice, it wasn't recorded, and therefore you have an unrecorded lien, as a result of which you have an unsecured claim in the bankruptcy case rather than a secured claim. And I might add here that the reason why it's important to have a lien is that a lien flows through the bankruptcy. In other words, even if the debtor is discharged from personal liability, if you have a lien on property, then that is not discharged in bankruptcy, and that can become a source of recovery. So that's why it's important and that's why the trustees in these cases try to avoid these liens. So that's why it's important to think about ways in which you can have various liens and have them secured prior to the bankruptcy, so that can be a source of recovery for you, potentially in the bankruptcy case, as opposed to having an unsecured claim. And if you're an unsecured creditor, then you're sharing pro rata with other unsecured creditors. That's something worth keeping in mind in terms of attorneys and trying to get paid in the event of a bankruptcy, whether that is by, as a result of the other party or your own party. If it's your own party, then obviously the liens become very important as a secured claim. And if you're not, then you want to focus on other ways in order to get paid. And we talked about having it characterized perhaps as a domestic support obligation, or having it characterized as a 523A15, a non-DSO debt obligation. And I have seen cases where the attorney is successful in going into the bankruptcy court and arguing that it's non-dischargeable under 523A, that the attorney's fees are non-dischargeable under 523A5 and A15. So we're almost out of time here. I wanted to open it up to see if there's any additional, well, in terms of a wrap up. So the notion And then I'll get very briefly to questions if there are any. Be careful about the automatic stay, assess its applicability and the exceptions and take appropriate action. That may mean going to the bankruptcy court and getting a comfort order, if you will, or if it's for equalization of marital assets, then you certainly want to get relief from stay, understanding that there's going to be some oversight in one way or another from the bankruptcy court. Certainly want to keep informed on bankruptcy proceedings and what's going on there and whether debts are properly characterized and treated, and if not, take prophylactic action to make that happen. And then also we've talked about if you've got some potentially non-dischargeable debts for fraud and breach of fiduciary duty and embezzlement and whatnot, and willful malicious injury, want to potentially pursue that recovery in bankruptcy and be mindful of the timing there. Certainly be mindful of domestic support obligations and property division claims in their treatment in the bankruptcy case, and act as necessary there, and stay current on legal developments, obviously, and then plan ahead. Bankruptcy, as we started, sometimes bankruptcy happens suddenly, and so while you're in your family law cases, you may want to consider, even if bankruptcy doesn't seem likely or even possible, things can happen quickly. And so you may want to kind of plan ahead or think about that in advance and put things in place so that if that bankruptcy happens, you're well situated to navigate the bankruptcy in the family law context. If there's any kind of last minute questions, I'm happy to answer questions now. If there aren't any, by all means, there's my contact information. You can certainly contact me at any time at your convenience, and happy to chat with you about that. Also, it's not part of the materials that you'll be getting, but I've also written an article on marital property agreements. I mentioned the notion of them being subject to fraudulent transfer statutes, and I've written kind of an article about that. I had an experience in a case where that came up, and how to address that. Chapter 7 trustee filed an adversary proceeding against my client from Missouri, trying to essentially blow up the whole dissolution, resolution, and divorce decree in the bankruptcy, or in the family law case in Missouri, brought it out here in California, try to unwind everything. And so we had to kind of deal with all of that, and we did. So happy to chat with you about that. It's a matter of public record. We ended up resolving that matter pursuant to court authority, but I wrote an article on that. So if you're interested in that, certainly email me, and I'll be happy to send you a copy of that article.
All right, James. So it actually looks like we have quite a few questions if you'd like to take the time to answer those. All right. So Martha Warner asks, is the portion of a family law judgment that awards back wages to a spouse non-dischargeable under Section 523A.15?
It could be potentially under A15, or I'm wondering if it may be under could it be a domestic support obligation in some form or fashion?
Right. And then let's see. Jack Russo is asking again, can an attorney lien be perfected by filing against the litigation file? Else how?
I'm not sure if it could be perfected. There's issues. The charging lien is in terms of the litigation itself. I don't know that. Maybe if the property is subject to that litigation itself. I think in the Bush case, or in some other cases I was looking at, not clear about the interplay between what you can record vis-a-vis the action itself, or I think it's on causes of action, or so I'm not really sure about that, to be honest with you.
Okay. And then Jack asks again, can a consulting attorney file a lien even if you're not, or the consulting attorney is not of record in the case?
I would argue, well, I think you can try to go down that road, or you can potentially, in terms of being a consultant, maybe have it considered as a domestic support obligation.
And then I have another question. Suppose in a Chapter 7 case, only one spouse is filing. The non-filing spouse bought a property after the marriage, and the filing spouse signed an interspousal transfer deed at the time, giving up any ownership interest and simply residing there. In that scenario, does the property still need to be listed in the filing spouse's schedules, and how would it be treated in the bankruptcy?
Well, the Chapter 7 trustee would probably look at that underlying trend. You'd want to, in terms of that transaction, you'd want to document it, and you'd want to be clear, I suppose, in terms of giving up any interest. It sounds like it was separate property, and so that sounds like it might be outside the bankruptcy context. But think about whether the trustee may try to argue that that the spouse that didn't file bankruptcy, whether there was some kind of contribution to that particular asset. So, for instance, suppose his or her wages were then used to pay down the mortgage or something like that, or improvements to the property. Consider whether that there's the possibility of gaining some kind of equitable interest in the property, which then potentially could be subject that the trustee may want to look at or claim an interest in. But in the absence of that, I mean, if you've got separate property and you're really clear about that, then you'd want to be, in the bankruptcy context, you'd want to make the argument or be clear as to the schedules and whether it's considered, whether they're characterizing it as somehow a community property asset, and then, in a sense, dialogue with the trustee, or maybe need to seek relief in the bankruptcy case in order to get some declaratory relief or some kind of resolution of that issue if that comes up.
All right, thank you. And let's see. Can the prevailing party's legal fees be added to the lien claimed, or are all these added fees get cut off as of the BKY filing date?
Like, I guess it depends. In part, that may depend on your attorney for whom. I mean, I would argue if you have a lien, if you have a lien, that it could cover pre and post petition fees. In the Bush case, for instance, they found that the charging lien applied not only to pre-petition but post-petition fees. The other side tried to argue that that it didn't apply to post-petition fees, but the bankruptcy court in that case anyway, in dealing with the real property and it being an exempted real property, felt that it didn't impact the bankruptcy at all because it was a lien on exempt property. A little bit more fact intense, you know, so it really kind of depends on the facts, but I certainly would argue if you have a lien that goes through, it does. If you're representing your client who then files bankruptcy, there's the pre-petition stuff, but you may want to work out an alternative agreement, like in the context of the bankruptcy, maybe to be employed by the bankruptcy estate in order to be sure of getting your fees paid post-petition. I'd want to look at that and not rely on a pre-petition fee agreement, because I have seen situations where there is some talk, as I alluded to, about whether that's an executory contract, meaning duties and obligations on both sides, and in the bankruptcy context, whether that can be kind of assumed, if you will, meaning kind of taking on the responsibilities, or it ends up being kind of rejected. So those are some things to think about, I would suggest.
So we have some more questions. One from John asks, if not a divorce and one person files, is the entire community estate subject to trustee action?
Yeah, if there's not a divorce and there's community property, yeah, then community property is considered a part of the bankruptcy estate, and so that will be adjudicated in the bankruptcy if there's not a pending divorce.
Right, and another is the withdrawal from an individual retirement account subject to automatic stay.
I think I don't. Short answer is I don't know, but I think retirement funds are maybe exempt from property of the estate. I'm not sure if that answers the question.
Okay.
For anyone that I'm not, if you have follow-up questions to those who have asked questions and you want to have more fulsome discussion, happy to have that offline.
All right, so it looks like we just have a couple more.
Okay.
Are there any state bar rules that bar these recorded lien rights?
Well, certainly one could do a deeper dive on that. I think I only am more aware of the charging lien, and the charging lien has certain under the fee agreement, there's certain requirements in order to have a charging lien. And certainly we've talked about the family law provisions, which is under California law as well. There may be other obligations, but those are the ones that I'm most aware of.
And what is the sentence or paragraph you recommend in a fee agreement, and must an independent counsel review and bless it?
Happy to talk offline about that, but
Okay.
yeah.
Okay. So it looks like that's just about it for questions. If you do have any more questions, feel free to reach out to Mr. Menton at his email address provided on the slide. Thank you so much, Mr. Menton, for your time today, and thank you so much for our audience for joining us. Have a good afternoon, everybody.
Thank you.